I'm Brian Pemberton, and I'm chairman of the Marine Advisory Committee. Let me take just a minute to kind of, for those that may not be familiar with the MAC, or Marine Advisory Committee, what we do. We're representatives. None of us are employees of the port. We're representatives of different constituencies within the port. Jim Young, who is with us over here, he represents small vessels that are in the harbor and is a tenant in the harbor. Peter Border is a representative from the Coast Guard Auxiliary. And we have representatives from charter companies, from liveaboards, boathouse owners, condo owners, larger boat owners, a variety of representation. The committee really is composed to help represent all of the tenants. It's your committee. When the state of Washington passed some new laws and regulations, our committee reviewed those laws. We recommended to the port commissioners that the port's rules and regulations be in harmony with the new state laws. The commissioners adopted that law, and so the commissioners requested, where's Dan? Oh, there he is. Dan Stahl, who is one of the executives with the Port of Bellingham. He's in charge of marinas. And the commissioners directed Dan to implement the new state law within the Port of Bellingham. And as a result of that, all of us who are tenants here in the port received a notification, a letter from the harbor master and assistant harbor master. By the way, if you don't know the faces that were on the bottom of this letter, Kyle and Andy over here are harbor and assistant harbor master, who were the ones that carried out the assignment to notify all tenants that there were changes in the state laws that the port was required now to fulfill. As we go forward, if there's any questions, if anybody has any comments, it's a relatively small group here. We invite you to ask questions. We invite you to make comments. All we ask is that be a little sensitive to time, and also sensitive that we try to be as congenial as possible as we go along here. Our feelings get hurt easy, so be easy on us. Would you like to go ahead, Vicki, and start in with a little bit of a review of why it is that we find ourselves needing additional information?
Okay.
I might mention that Vicki is with Alliant Insurance Services, who handle the port's insurance requirements.
So thank you for coming today, and thank you for inviting me. The other producer that I work with is actually homesick today, so I'm on my own, and I hope that I can answer most of your questions. Basically, the background behind all of this is that the state has been paying a lot of costs in cleaning up boats that have sank. They want to increase vessel ownership and address the challenges associated with the cost of removing vessels from the water. Over the years, it's been a very expensive endeavor for the state to clean up after all these boats, these derelict boats that sink in the water and need to be cleaned up. So they addressed a new law. They did a lot of research and talked to all different kinds of groups, several different types of groups, and came up with several different recommendations. And then this law was actually, I think it was brought up in April and then signed into law as of July 1st. I left my PowerPoint sitting in here. June 12. The law was effective June 12. So basically, and I put one of these on the back table for everybody if they wanted to get a copy. So the law requires, it's a new state law, the following is required for all public and private marinas, and it's identified in the law as moorage facilities in the state of Washington. The law requires that all vessels moored at marinas have the following insurance covering the vessel for general liability, legal liability, and pollution liability, with a minimum policy limits of $300,000 per occurrence. General liability is third-party liability, which is bodily injury or property damage to others. The legal part of that would be defense expenses and claims expenses. And the pollution part of that would be oil spill cleanup and containment. If the boat sinks and spills oil or fuel into the water or the environment. All types of pollution and oil fuel spills can cause a lot of damage to the environment. And that has happened here at the port and several of our other ports that we insure in the state of Washington, or that we're the brokers for. So cleaning up after a boat that sinks is very expensive, and part of that is the pollution that happens and that has to be contained according to the Coast Guard rules and Department of Natural Resources rules. So the port and the marina is required to obtain as a condition of moorage proof of insurance for non-transient vessels mooring in the marina. And again, the insurance requirements are $300,000 per occurrence minimum limits for general, legal, and pollution liability. Under the applicable state law, a vessel is defined as every watercraft used or capable of being used as a means of transportation on the water, so it's a very broad definition. For public moorage facilities, marinas, such as the Port of Bellingham, proof of insurance is required for all non-transient vessels. This applies whenever a moorage facility operator enters into an initial moorage contract and at every renewal. Any moorage facility operator that fails to satisfy the requirements is not eligible for reimbursement from the derelict vessel removal account. So to encourage vessel registration, the new law requires all public and private marinas to obtain entering into long-term moorage agreements to obtain the following information: the legal owner of the vessel, a local person's contact information if it's different from the owner's address and telephone number, the vessel hull identification number, and if applicable, the vessel's U.S. Coast Guard registration, the vessel's home port, and the date on which the moorage began, and the vessel's country or state of registration and registration number, and proof of vessel registration, statement of lessee's intent to register, or an affidavit certifying that the vessel is exempt from registration. So the marina has a big responsibility to meet the state law. The Port of Bellingham is required to obtain proof of insurance on all non-transient vessels moored in their marinas in order to comply with the law and to be eligible for reimbursement from the derelict vessel removal account. One of the things that we recommend on all moorage agreements is that the Port of Bellingham require that they be named as an additional insured on all insurance policies related to vessel moorage agreements. And that's to help protect the port, and they have access to the insurance should it be needed to pay the costs of a claim, such as a boat sinking, pollution liability, that sort of thing. So any questions on any of that?
I actually have a question on the additional insured. We get that question a lot. And what specifically, can you give an example of how that additional coverage would help either the boater or the facility?
The Port of Bellingham being named as an additional insured on the boat owner's policy gives you access to their insurance.
Okay.
To help pay for the costs of a claim, such as the oil spill cleanup, the wreck removal.
So if a vessel sinks and goes to the bottom and begins emitting pollution, let's say, inevitably the port ends up contracting with a diver to bring that up.
Right.
Does that diver have to contract with the vessel owner, or can the port incur those costs and then go directly to the insurance company?
The port can incur those costs, which actually I think is the most economical and quickest way to get it done, because you have to get out there and do it now.
Right.
You can't wait until the boat owner's insurance company approves it or anything. You've got to get out there and contain the spill and do it now. So yes, you incur the costs, and then you can go back on the boat owners insurance to get reimbursement, to ask for reimbursement from their carrier.
Okay. Thank you.
Good question.
I actually just want to comment one other part of that additional insured. When you were listed on a personal, on a policy as an additional insured, you're actually covered for something that you could be held responsible for the negligence of the actual insured. So the insured does something wrong, and you could be brought into like a lawsuit.
Right.
You're actually covered as part of their policy.
Right.
But it's only going to be related to something that they are actually negligent for.
Right.
So.
Okay, and you also mentioned that all vessels, period, need to have insurance, so does that count for, I know a lot of tenders are covered under the primary vessel's insurance, but if someone just wanted to berth a dinghy in our harbor, would they have to have it insured?
Well, if the dinghy has a motor that can have a fuel spill,
Okay,
because basically the law is every watercraft used or capable of being used as a means of transportation on the water.
okay. I asked
So it's
because
such a broad definition that
Right.
it's
I know
hard to
not
say.
all dinghies, for instance, must be registered. I think the
Right.
law is less than 8 feet and no motor, they do not have to be registered, but once you add a motor to it, it would have to obtain a registration. So even if they didn't require registration for that dinghy, we would still require insurance on the dinghy?
Well, to comply with the state law, it's a very broad definition.
Right.
I think it's more, probably need to have some more, probably look into that a little bit further, because I'm really not sure on, I don't do boat owners,
Right.
so I don't know
Okay.
all the laws related to that.
Okay.
But I can check into that some more.
Vicki, were you also going to talk a little bit about new vessels, insurance requirements, or?
Oh, that's what this was.
Yeah,
The new
okay.
vessel insurance requirement, sorry.
No problem.
I just went right into it.
Good. John Miller is with Hub International, and they're one of several firms that provide insurance, yacht policies, boat coverage insurance to individuals to cover their boats. And we asked John if he would help at this meeting to explain some of the terms and some of the concerns that those of us who are boat owners might have with the change of here in this, with the change in the law. John?
Thanks, Brian. My name is John Miller, and I'm from Hub International Northwest. We're a local broker right downtown. I've been doing insurance for about 14 years, so thanks for inviting me down. Appreciate that. First, I do want to do a disclaimer, which is I'm going to speak in generalities. Each insurance policy is going to have its own policy conditions, rules, regulations. You do need to consult your own contract and speak with your own insurance broker or agent about that. So just want to get that out of the way. Thanks, Vicki, for talking about the House bill. One part of the bill says that you just need to have $300,000 of liability coverage with regards to having your vessel at the marina. The liability does need to include not only liability for damage and injury to others, which is the liability portion, but you also need to have fuel spill coverage. So you want to make sure you check with your policy to make sure that is covered. Generally, it is going to be covered under the liability portion, but the government can get you for more than the $300,000 minimum that they're actually asking for. The Oil Pollution Act says you actually are responsible up to $854,400 for fuel spill, and your policy, if you only have $300,000, you now have a gap in your insurance. So you might want to speak with your agent about that if you only have $300,000 or even $500,000 on your policy. And I'll go into a little bit more about that later in my presentation about how you can obtain those limits really to protect yourself. The policy for boat insurance, for you to get the liability, you have really two options. If you own your boat personally, you can get a personal watercraft policy, a personal boat policy. It could be a yacht yacht policy. It really kind of depends on the length of your boat, size of your boat, which type of policy you're going to qualify for. I am probably going to be interchanging those terms quite frequently. Boat insurance, watercraft insurance, marine insurance, yacht insurance. To me, it's all boat insurance, but we'll get into that here in a little bit. The other part is on a commercial policy. If you have a boat that's part of a fleet, some sort of commercial enterprise, your liability on your marine policy is actually going to be called P&I, which is protection and indemnity. When you have a business, you have something called general liability, which is going to cover the business, like land-based portion of it, which always has a marine exclusion. So you need to add on P&I, which is going to then give you protection and indemnity, which is where you're going to get watercraft liability. So I know with you guys at the port, people are probably sending you things that may say general liability. You really want to be looking for something that says P&I. That's actually where the watercraft liability portion comes from. There is also something in commercial insurance called marine general liability, which is actually a combination of both of those things. So you definitely want to make sure your policy says P&I, and if it doesn't, you want to at least make sure it says marine general liability. So when you have a boat and you want to get insured, how do you actually get a policy, and what type of policy are you going to require for your boat? You have a couple options on a personally owned boat. Sometimes you can actually add a boat onto a homeowner's policy. There actually is an add-on, which is called an endorsement to a policy, where you can actually get watercraft liability. You can even get hull coverage, which is going to cover the boat itself. It does meet the requirement for the marina and with the law, because it is marine insurance. It does provide liability, it does provide the pollution portion of the liability. However, it's now attached to your home policy. You happen to have a boat claim. It actually is technically a homeowner's claim. So your homeowner's insurance is going to go up, which is never a good thing. So our recommendation for people who have a boat is not to have it attached to their home. Keep those two items separate if you can. The other thing when it's attached to a homeowner's policy is that you're not going to get as broad of coverage as you would under a separate boat policy. There's some things in those boat policies that provide additional coverage, things like uninsured boater liability, which is if you get injured on your boat from a person who doesn't have insurance or enough insurance. It's not available when it's attached to your homeowner's policy. The Marine doesn't require that coverage. We always recommend people have that coverage because you just never know what's going to happen out there. The other is the boat policy has, with a boat, when it's insured under a homeowner's policy, has different navigational territory options for you where you can actually boat. So if you're trying to go up to Southeast Alaska or west side of Vancouver Island, you need to make sure you actually have a boat policy because they can extend those navigation limits. Depending on the homeowner's policy, it could be anywhere from 50 miles offshore to 100 miles offshore, maybe somewhere in between, but it just kind of depends. You need to check those contracts. And then when you have a separate boat policy for it, you can actually get generally extensions of your navigational territory. So some people kind of forget where they say they're going to be boating and then end up in hot water, so to speak. So the other thing, which is really important to the port, is when you actually have it on a homeowner's policy, you can't actually add the port as an additional insured when the boat is attached to a homeowner's policy. Because the only way to do it is really to attach the port as an additional insured on your home. That's how those contracts work. And a homeowner's insurance company does not want to list the port as an insured on your home policy. So to meet the port requirement, it really does need to be on a separate boat policy. The types of policies you get really kind of depend on the vessel that you're trying to insure. Generally, a watercraft policy or a boat policy, personal boat policy, is going to be for a boat that is 27 to 30 feet or under. That's generally what they call a boat. Anything over that, they sort of classify as a yacht. Their difference is in those contracts. Yacht policies allow you to have expanded navigational territories. You can get coverage if you're going to charter, if you're going to use the boat for other like commercial purposes and things like that. And so depending on what you're using your boat for, is you need to really speak with your agent about that to figure out where you need to like place your boat for coverage. And when you have a commercial boat policy, it's really going to be a marine policy, and those cover different things. So the policy for a boat really has two halves. There's two halves to it. There's hull coverage, and then there's the liability. So the port, you guys don't care if the boat actually has coverage for itself. You just want to be covered for the liability. So whether or not you want to choose to insure the boat itself, that's up to you. But for the liability is what the port's really going to require. Most insurance companies, though, if you don't want to insure your boat, they usually want to know why. Why don't you want to insure your boat itself? So if the boat is not in a condition that may be seaworthy, where you don't feel like you want to insure it, they also may not want to write the insurance on it because perhaps there's a reason why you don't want to insure it, and it actually is going to pose a liability issue in the future. Fuel spill, fire, something along those lines. The liability on a boat policy is usually what's called a combined single limit. We were talking about $300,000, and a combined limit means, or $500,000 or $1 million. And what that means is you have a lump sum amount of coverage that you can use for someone being injured, property damage to others, fuel spill. All of it is combined together in one lump amount, and it's per occurrence. So you have one event, you have that one amount that's going to pay out. On a commercial policy, you're generally going to see something that has per occurrence plus aggregate. And what that means is that for any one event, you have like $1 million that's going to pay out. But for your policy period, they're only ever going to pay out $2 million. That's the aggregate. So you could have 4 boat claims. As long as it doesn't meet the $2 million aggregate, you have coverage. And as long as none of those events are over $1 million, then you have coverage for that. So if you have 2 major boat losses, $2 million claims, you're capped at $2 million. So I know a lot of people have questions about, my policy says I have 1, but it also says I have 2. What does that mean? Per occurrence, aggregate for the total they're going to pay out for everything that happens during the policy period. But you're always capped at that aggregate amount. The policy limits that you can get on a boat policy for the liability, they start at $100,000. You can go up to 3, you can go up to 5. Most personal boat policies are going to cap the liability that you can get at $500,000, which actually leaves you with, okay, how do I get a higher liability to protect myself? And through that, you can get a personal umbrella policy. That's what most people do. So if you have a bad boat accident, your policy is going to pay out, it's $500,000. You might have $1 million umbrella or a $2 million umbrella. Those stack on top of each other there. So if you had $1 million umbrella, you'd really have 1 plus the 5, so $1.5 million. But let's say you have a pollution spill because of that. Well, I have a $1.5 million. I have that much liability coverage. But you don't, because the umbrella policy itself has an exclusion for pollution. So your boat policy is going to pay up to its limit, which could be $500,000 if that's the limit you've picked. But an umbrella policy, they typically have an exclusion for pollution. So that means you're still going to be on that hook for that other $354,400 because you have to, because the government can get you for $854,400. So in order to protect yourself further from that, you need to make sure you can maybe get a boat policy that's going to have either $1 million of liability. There are also boat policies that will cover you up to $500,000 for the liability, but for pollution, there'll be a rider on the policy that says, but we'll actually cover you up to $854,000 for the pollution. But you have to look for that. Not a lot of companies offer that, but some of them do. So if you have any questions about that, ask me about that later. Yeah, the Pollution Act with the umbrella exclusion, I always like to remind people of that because they think they have coverage for it, but they don't. So for you guys for at the port, someone might even be sending you like umbrella. I don't know if you guys ever get umbrella policies from people, but typically there's exclusions for pollution in those. So it's not going to meet your requirement. A big question people always have on a boat policy is, where do I get coverage for wreck removal? Wreck removal generally is going to be paid out through the liability portion of the boat policy. It's usually a separate amount from the liability itself, but it pays out through that as an additional limit. You could have a liability loss, let's say where you hit another boat, your boat sinks, there's a liability limit that pays out of $300,000. There is a separate limit generally in those contracts for wreck removal. Again, consult your own policy, consult your own agent, but it'll pay out, it's up to your liability limit for wreck removal. The issue with wreck removal, though, is that they're only going to remove it if they're legally liable to do so. That's actually how it says. So if the Coast Guard comes and says, you need to move your boat, okay, now they're legally liable to do it. Otherwise, they're just going to kind of keep it where it's at. The other thing is that on some boat policies, you don't see it very often, but they will actually pay wreck removal and subtract it actually from the whole value. So if you have your boat insured for $30,000 and it's going to cost them $15,000 to haul it out, they're only going to pay you $15,000 for your boat. You don't see that very often, but that is out there in some boat contracts. So watch out for that. And when you buy your boat, a lot of times these insurance companies are going to require a marine survey. And I know a lot of questions come into me about, okay, when do I need a marine survey? Where should I go? What are they going to require? And you guys, I'm sure, get those questions fielded to you all of the time. So survey requirements. Typically, if the boat is 10 years or newer, 10 years old or newer, they're not going to require a marine survey. They're going to think that the boat is in good condition. If you're buying a boat, I think you should always get a marine survey because you just never know. It's kind of like when you buy a house, you should always get a home inspection because you just never know. Even though a house could be brand new, there always could be an issue with that. So a boat is no different because you need to know what you're getting yourself into when you purchase those. The boats that have wood hulls, though, even though the boat might be new, they usually require those surveys every 2 years if you have insurance. A lot of times they want them out of water, I know, which is tough on those wood hull boats, but because it's a wood hull boat, they want to make sure there's not an issue with the boat itself. So we can see that a lot where people are like, ugh, I don't want to take my boat out, but usually it's every 2 years on a wood hull boat. The survey options, when they come back, when I look at those, there's always going to be, when you see those, it's going to have critical things that are critically that need to be done with the boat and other things that are recommended. Critical recommendations versus non-critical. So when you are trying to get insurance on a boat, the insurance company is always going to want the non-critical items taken care of. Now, you may just be buying the boat today and you need to have insurance out on it as of today. They will usually give you a time frame of which to get those done. And it's usually 30 days. Sometimes they'll even let you go further than 30 days. But they will have you fill out a compliance, it's actually a compliance list, of when you're going to get those items done. The things that they're always concerned about are going to be things that are either A, going to sink the boat or catch the boat on fire. Those are the two big ones. Makes sense to me why they might be concerned about those items. The non-critical things like, oh, it's missing a whole registration plate. Oh, this pipe looks to be like loose. Those are non-critical items. They always want anything on a survey that comes up to be fixed no matter what it is. But non-critical, they want done first, and then they'll usually give you throughout the rest of the policy period to get the non-critical items done. They like to see pride of ownership. because they figure if you're going to take care of your vessel, you're probably going to operate your vessel the same way with the same care. So they like to see those things done. Insurability for these boats, a lot of times when you have an older boat, it's tough to get insurance on an older boat. A lot of things that are wrong with it, mechanically could be wrong with it, there could be fuel problems with it, and age is always going to be a consideration. Anything that is over 30 years old, they are always going to require any company a marine survey for, just to make sure it is a safe vessel. The other types of boats that insurance companies have issues with a lot of times are hull shape, actually. A lot of companies hate catamarans. They don't like V-hulls or split hulls. They don't usually like to write even wood hull boats. We usually have to go to a specialty market for those. There's some beautiful boats out there, wood hulls, and they're tough to get insurance on, especially those older wood hull boats. We usually have to go to non-standard boat markets to actually even get coverage for those. There are a few companies that are now specializing in that, and we usually we can find coverage for them, but they're tough. They're tough. They make you go through the hoops to get coverage on them. The other thing with boats that are salvaged. They're not a big fan of those. You usually can't get coverage on the hull itself. A boat policy has two parts: coverage on the hull and liability. And if a boat's been salvaged, it's already been paid out, its value is actually zero, so they won't actually usually insure a boat again. They'll insure it for liability, but they actually won't insure the boat itself. And those we run into sometimes when people are buying like used boats, which is always a good idea to have a survey done, find out what the history of the boat. So.
John, thank you. Listening to John go over these items, I'm reminded that I think we're all fortunate to having insurance advisors who think staying up at night and reading insurance policies is fun.
Yeah, I have a problem.
In my opening comments here, I made a mistake in introducing one of our port staff. I introduced Andy here as the Assistant Harbor Master. Excuse me, that Andy is the Blaine Harbor Master and Kyle is the Squalicum Harbor Master. So Andy, didn't mean to give you a demotion here.
Yeah. The general liability would be your third-party liability, such as bodily injury, property damage. The legal liability is the defense expenses, claims expenses. So, for instance, if something bad happened, your boat sank or caught on fire, the general liability is going to pay bodily injury if somebody was injured in the fire, property damage if another boat is injured, or if another boat is damaged, or if the dock is damaged. So that's general liability: bodily injury, property damage to a third party. Legal is going to pay the claims expenses, attorneys, defense expenses, the cost for surveys, the cost for inspections, the cost to whatever claims expenses, whatever legal expenses are attached to it. Defense, attorney costs, that sort of thing.
Different than the 300,000?
That's all going to be combined into one. Some policies have, as John was explaining, some policies have a combined single limit, so you're going to get 300,000 to pay bodily injury, legal expenses, and pollution. Some policies will have the property damage, general liability, and the legal expenses under one limit of the 300,000, and you might have a separate limit for pollution. You just have to know what your policy reads. And a lot of times the wreck removal is a separate limit, a sublimit or a separate limit. So you have to read your policy, and if you don't know what your policy says or you don't understand it, then talk to your agent. But they are three separate coverages, And in some cases, they might be one limit under the policy, in another case, they might be two limits under a policy.
And some, oh, sorry, Brian.
Excuse me, John. I was just going to say, I think the point there is in the law, Jim, is that your policy has provisions to cover
All three.
All three.
Under the 300,000. I see what you're saying, yes. You don't have to have 300 for general, 300 for legal, and 300 for pollution. It's just 300 that will cover all three of those things. Sorry.
John.
Yeah, and I was just going to say too is that and sometimes even on those policies that the defense costs and the legal portion is not even part of the 300,000. It's actually its own separate limit. It's not even.
Or sometimes it's unlimited.
I was just going to say, yeah, sometimes
Yeah.
it's even unlimited too.
Yes.
So.
That's true.
Good questions. Any other questions? Well, we'd like to thank you all for coming. Please feel free when we get through, and a big thanks to both Vicki and John. Thank you very much for coming and helping us with this discussion. Dan, do you have any further comments or anything you would like to make?
No, I'd just like to thank you guys for taking the time to prep for this. Great questions from the audience, good give and take. The reason for us doing this came from one of the MAC meetings where some of the members were saying, hey, the law's new, what does it say? And there was a lot of confusion. And so we wanted to bring together you guys that purchased the insurance with some of the providers and just try and get that discussion going so that hopefully you found this valuable. And we're here to serve your needs, and just thank you for coming.
And if any of you, please feel free, Allstate in the background here, John, Vicki, any of the staff members will be hanging around. As long as there's food in the back, they'll be hanging around here. And feel free to ask them any questions you might have. Thank you very much.